Welcome to class number 10 of our 2022 Virtual HOA and Condo Academy. In partnership with the cities of Avondale, Chandler, Glendale, Goodyear, Mesa, Peoria, Phoenix, Scottsdale, Surprise, and Tempe. I'm so glad that you could be here today to talk with us about enforcement of CC&Rs and collection of delinquent assessments. My name is Beth Mulcahy, and I am the managing partner and senior attorney for the Mulcahy Law Firm in Phoenix, Arizona. I've enjoyed working with HOAs and condominiums for the past 25 years, and currently my firm represents over 1,000 planned communities and condominiums throughout the state of Arizona. I also have served on my board for my HOA and condominium for many years, and so I think I bring a good diversity of information and experience working with associations as their legal counsel, and then also serving on my board. Before we dive into today's seminar, I would like to start off by getting a feel for who's here with us today. It's always helpful for me to know how many board members or owners or managers that we have here with us so that I can tailor my presentation. So we're going to launch two polls for you right now at the same time. So the first question is, in which city do you reside? And then the second question is, let us know what your current role is with your community. Are you a board member? Are you a community manager? Are you an interested homeowner? Okay, let's dive right in, and then we're going to give the poll results here in a few minutes once the numbers come in. What are we going to work on today? In today's session, we're going to cover the enforcement of CC&Rs and the collection of delinquent assessments. I'm also going to give an overview of the new HOA and condominium laws that went into effect on September 24th. We're going to be talking quickly about 5 bills and give you a useful handout that you can use if you have any further questions on that. Okay, before we dive in, let's see who is here today joining us. We have a really great representation from basically all over the valley. So we have 3% that are here from Chandler, 8% from Glendale, 3% from Goodyear, 24% from Mesa. Wow, big turnout from Mesa today. 3% from Peoria, 24% from Phoenix, 29% from Scottsdale, and 8% from Surprise. So really basically almost every different area in the valley are here today as participants in the seminar. So great job. Our second question is, what is your current role with your communities? So 66% of you are board members, 11% are managers, and 16% are homeowners, with 8% following up as other. Okay, great. So we have a really diverse geographic group today with us, and we also have a large number of board members and almost an equal number of managers and homeowners that are here. So welcome to all of you. Okay, so first thing we're going to talk a little bit about is the 2022 legislation. As you probably know, the legislature adjourned in late June, and there were 5 bills that were introduced this year that pertain directly to HOAs and condominiums. All of these bills went into effect on September 24th, and we have a really great cheat sheet, which is a deep dive on the 5 different topics of the new bills that pertain to HOAs and condos. We also have a great blog on one of the bills that we're also going to be sharing with you. Okay, so just real briefly, the 5 bills were, let's see, there's 4 out of the 5 are definitely things that we'll see on a weekly basis in my practice, and with questions from board members and homeowners. And then there's 1 bill that really won't come into play very often. So the bills that we're going to see pretty regularly are, there was a bill on artificial turf and the fact that HOAs can no longer ban artificial turf. We can pass some rules regarding the artificial turf in terms of how it can be installed and the grade and quality and maintenance of it going forward. But that was an important new bill that was passed this year that, of course, only applies to planned communities. Then we had 3 other bills that apply to both planned communities and condominiums. One deals with political and community activity, and it extends the type of political signs that can be put up in a community, whether it's planned community or condominium, to issues that pertain to the association, like board members, elections and board member removals and maybe initiatives that are coming before the community for a vote. So that bill really extends the right of owners to put up political signs for their own association issues, and the association cannot prohibit that. This bill also gives the right for community members to peacefully assemble on the common areas with some restrictions. The board can pass rules regarding that. The third bill talks about first responder flags and gives owners a right to fly a first responder flag on their property. The fourth bill deals with short-term rentals and enforcement of short-term rentals, and it has basically it gives cities, towns, and municipalities a lot of leeway and authority to pass rules and ordinances that would require landlord owners to pay a permit fee and register their short-term rentals with the community that they live in, meaning the city, town, or municipality. We can also require them to notify the neighborhood if it's going to be becoming a short-term rental, like the immediate neighbors, et cetera. So that's just an attempt, I think, by the legislature to put some additional teeth in the law so that some of these out-of-control short-term rentals can now be better managed by the cities, towns, and municipalities. And how that will impact associations is that if we have a bad short-term rental, what we can do now is, if the city is passing ordinances, and most are, in our experience, we're finding that most cities are in the process or already have some ordinances in place to regulate short-term rentals. The associations, HOAs, and condominiums, if they have a problem short-term rental, they can complain to the city, and the city will be investigating it and looking for any violations of this new law. The last bill that was passed this year deals with condominium termination, and basically it just gives a procedure to terminate a condominium after any new condominiums that are established after the effective date of this legislation. So we don't really see that bill as coming into play that often because typically condominiums aren't terminated very frequently. It's a very unusual thing to have that happen. Okay, so keep your eye on those bills. Surprisingly, we haven't had too many questions about the new legislation, but I'm pretty sure that we'll start hearing, more about the political signs in communities and also short-term rental issues, especially as we're getting closer to the Super Bowl coming up. So we'll be talking about a lot of those topics as we move forward. Okay, let's get right into our presentation for today. We're going to be talking about enforcement of CC&Rs and what can associations do to effectively enforce their CC&Rs. And I would say, probably just as an introductory remarks, some of the most common questions that I get as legal counsel for associations is, how do we handle this particular owner who is not abiding by the association's documents? And we're going to give some examples later today of what are the most common enforcement problems, but just off the top of my head: parking, not getting architectural approval prior to making changes to their property. Short-term rentals are a big enforcement issue right now in communities. Not paying assessments on time, not maintaining their property. These are probably creating a nuisance in the community. These are probably what I would call the most common violations that we see. And so today, kind of what we'd like to do is talk about, okay, every association has violations. How can we best handle these violations so that we correct the violation and we try to make sure that the violations don't continue by the same owners again and again and again? Okay, we're going to be sharing with you a really helpful cheat sheet. For those of you who may be joining this presentation for the first time, you may not be familiar with our cheat sheets, but we have over 60 cheat sheets on a number of different topics pertaining to associations. And basically, we write cheat sheets whenever we start to see a question again and again from clients. And we try to make it's a 2-page summary that you can read in 3 to 5 minutes and give you the full 411 on whatever the issue of the cheat sheet is. So we have 2 great cheat sheets on this topic. One is just a general one on enforcing governing documents, and the second one is on levying and collecting fines in a community association. Okay, so let's talk a little bit about how do we handle owners who do not comply with the association's documents. So we found that one of the most challenging things of serving on the board, and I just know from my personal experience, one of the most challenging things that I find being a board member, and I'm still a board member in my community, is when you have owners who just refuse to comply with the governing documents. And it just creates a lot of stress for the board, because usually other neighbors are complaining about the owners that are violating the documents. Or maybe their properties are an eyesore, or maybe they're, clogging up the streets with cars, or, changing the paint color of their home without getting approval and painting it a color that never would have been approved if they had asked for approval. These are the types of things that we typically see. So how do associations best handle violations when they occur in your community? And so what we found is that most associations start out by just sending a courtesy reminder letter, and that's typically sent by the board or maybe the management company for the association. Some associations do it by putting a door hanger on the door, like a little piece of paper that hangs on the door. Some associations send the violation notices, the courtesy reminder letter violation notices by mail. Some people send them by email. It really just depends on what works best for your community, and a lot of that is determined by how large your community is. In most cases, the courtesy reminder letter is effective, and in most cases, owners, will voluntarily comply with the request to, correct whatever the violation is on their property. However, like anything in life, there are some people who don't respond to the courtesy reminder letter or refuse to take the action that's requested. And so in those cases, then typically a second violation letter, a more serious, nature one, worded more seriously with maybe some enforcement type language is in there. And so typically the courtesy violation letter will give them, 15 or 30 days to correct whatever the violation is. The second letter, the formal violation letter, is going to be very firm and give a very firm deadline to correct the violation. Now, in some cases, the firm violation letter is going to threaten a fine against the owner for the violation. And we're going to talk about fines a little bit more extensively here in a minute. But the formal violation letter is definitely threatening to take this matter to the association's attorney, possibly to file a lawsuit against the association, depending on the nature of the violation, or to fine the owner. And of course, you have to give notice of the violation and an opportunity to be heard before you can levy a reasonable fine against the owner. In addition, there is a state law that requires that all violation letters to an owner must have certain language in it. And this is by statute. So if your association, is a smaller association, maybe you don't have a management company, it's important that you're aware that your violation letters need to have this language in it. And all this information is on the cheat sheet that we shared with you. But the language that you must have in your formal violation letter is that you have the option to petition for an administrative hearing in this matter in the Arizona Department of Real Estate pursuant to ARS 32-2199.01. Then parentheses says this was formerly handled by the Department of Fire, Building, and Life Safety. So it's just kind of a random weird statement that you have to have in that violation letter by law. And honestly, a lot of times the owners, when they contact the association back after receiving that letter, they say, I don't understand why you put that in there. And we have to say it's because the legislature requires that we have that language in there. Okay, so we've gone through kind of the initial steps on how to best handle the violation. One thing that I left out that I think is kind of important is Some smaller communities may have a very courteous and cordial relationship between members, like if you have 10 or 30 lots in your association or units in your association. And I don't want to overlook the remedy of, making a phone call or knocking on the owner's door to talk about the violation and see what the association, what's going on with the owner, why it's not being handled. And if there's anything the association can do to help facilitate getting the violation corrected. So I think it's important that I mention that, because in some cases, a phone call really can just address the situation. You don't have to get, formal with a courtesy reminder letter or a formal violation letter. Okay, so what do we do if the owner continues to blow off the association, which, at this point, maybe by sending the courtesy reminder letter and the formal violation letter at this point, really, in my experience, probably like 80% of the violations are corrected. But then there's that 20% that just refuses to correct the violation, or just for whatever reason is just ignoring the letters from the association. So what are some things that are more serious remedies that we can do to get the owner to comply? I think kind of the first one we should talk about are fines. Under Arizona law, we have the right to fine an owner for a violation of the CC&Rs, the bylaws, or the rules of the association. So if it's written down in the bylaws, the articles, or the CC&Rs that an owner has to do something or can't do something, we can fine the owner for a violation of that section. Now we have to set up the fine correctly under Arizona law. There's a very specific procedure. And the procedure is, first, the fine has to be reasonable. So the amount of the fine is important to carefully consider. Now, levying a $1,000 fine for not putting away your trash can within a certain number of hours after the pickup of trash is probably not going to be considered reasonable. But a $1,000 fence for a health and safety hazard on somebody's property, that, is going to be considered something that, in my opinion, would be reasonable. So first, the fine has to be reasonable. Second, like we said, it has to be a violation of the CC&Rs, the bylaws, or the rules. And then third, before we can levy the fine, we have to give notice and an opportunity to be heard regarding the violation of the fine. And so really the process has to be set up in a certain way if you're going to fine an owner. A lot of times clients will come to me and say, we just want you to send a letter to this owner telling them that they owe, a $300 fine. And really, I can't just do that in one letter, because the way that the law is set up, we have to send 2 letters, basically. The first letter is the notice of the violation. And we outline, what the issue is, what the section CC&Rs that was violated, potentially who witnessed the violation. And then we may say that the association is going to fine you for this violation and give the dollar amount, and then say, but you have an opportunity to be heard regarding this violation. And that's in the first letter. And the opportunity to be heard can be done a number of different ways. You can have a hearing in conjunction with the board meeting, where you invite the owner to come and talk with the board. You could ask the owner to write a letter to the board or an email to the board with their comments as an opportunity to be heard. And then after that time that you give them for the opportunity to be heard expires, then the board sends a second letter with either levying the fine or thanking them for correcting the violation, and maybe then you don't fine after hearing what they have to say. So really, it's a 3-part process before you can levy a fine legally against an owner. And again, this is set up under Arizona law. So we have to give notice to the owner of the violation, an opportunity to be heard, and then we can levy the fine. Or we can choose not to levy the fine after we hear what the homeowner has to say. Or maybe they correct the violation and we decide not to levy the fine. An important thing to remember is, I've been practicing law now for a long time, 25 years. And in the old days, back in the 1990s, we were able to lien on owner's property for unpaid fines. Unfortunately, that law changed many years ago, and now the only way that we can enforce the payment of the fines is by filing a lawsuit against the owner, obtaining a judgment against the owner. Typically, this is going to be in justice court because typically the fines are going to be less than $10,000. And then after we get the judgment against the owner for the fines, then we can record that judgment with the county recorder's office, and it becomes a judgment lien. And that judgment lien needs to be paid, at the time the owner sells their property. Or we can try to enforce payment of the judgment, which is just a piece of paper, through garnishment of that owner's wages, their bank accounts, or maybe if they have a tenant in any property that they own, we can garnish the rent of the tenant to pay the judgment. And so really just kind of the bottom line on fines would be that you have to set it up correctly with the 3-step process: notice, opportunity to be heard, and then levy the fine. And second, in order to legally enforce the payment of these fines, we have to get a judgment against the owner and record that judgment with, Superior Court. Some closing remarks on fines would be that fines really are a method to get compliance. Like an association shouldn't be budgeting. If you're doing your budget right now for 2023, you really shouldn't be budgeting, I think we're going to get $20,000 in fine income in 2023. That's not something that you should be counting on. We use fines as a tool to get compliance. So if you have an owner who is refusing to correct a violation, fining them may be a way to push them to do something, because they're starting to realize that, the violation not being corrected starts to cost them money. But the reality is that if you have fines that are, that you levy and they're minimal, meaning like less than $500, it's going to be, you got to weigh or balance. Do we want to file a lawsuit to collect the $500 in fines? Because it may cost you $1,000 in legal fees, which, the court likely will grant. But it kind of doesn't make sense to sue somebody for $500 and then spend $1,000 in legal fees. So typically, what we see is owners that have a large amount of fines, like over $2,000. Those are the people that the attorneys are filing a lawsuit against the owner for non-payment of the fines. And remember that you can negotiate on fines. If the owner corrects the violation and is remorseful about, the issue, you may want to waive the fines entirely. You may want to waive half of them. It's just a consideration, because the goal of fining is to get compliance. Now, just kind of a word of caution is that, if you have a habitual offender, you probably don't want to waive the fines, because they'll think that they can continue with the bad behavior or whatever the violation is, and that we're always going to waive the fines. So, there's no incentive for them to comply with the documents. And so in a timely manner. So you may not want to waive it on somebody who's a habitual violator. One thing I want to just close out fines and talk a little bit about is that management companies often place fines directly on the owner's ledger and after the fines have been levied. And it's a way for them to keep track of, the fines are owed by the owner, and it's now on the ledger so that we don't forget that this owner has fines against them. If the owner goes to sell their property and those fines are on the ledger, in our experience, we've found that, if the association discloses them at the close of escrow, typically those fines are paid, even though the association may not have a judgment yet. If you're in this situation as an association and you've levied fines against an owner and they're being disclosed at the time of a close of property, close of escrow, that, hey, this lot owes this amount of money in fines. If the seller objects to, the fines being on the ledger without having a judgment, It's something that the association should very seriously consider waiving and not collecting at the close of escrow, because remember, the law says that you are required to have a judgment to enforce collections of those fines. And if you don't have that judgment, the owner has a very good argument that they don't have to pay those fines. Okay, let's talk a little bit about another legal remedy. So self-help is another legal remedy that's an important one for us to discuss. So what is self-help? It's typically set up in your CC&Rs for your association, and it allows the association to give notice to the owner of the violation, and it allows the association to go in and correct a violation on a lot or unit at the owner's cost. And that only happens if the owner fails to correct the violation in a timely manner after receiving notice that they need to correct this. If your association's documents do have the self-help provision in it, it's a great remedy to go in and clean up a property. Typically, we see self-help with like tree trimming, landscaping violations, maintenance violations on somebody's property. It's an effective tool to go in and clean up the property. A couple thoughts on self-help are that, typically, so there's a cost to do this, right? And that cost typically is set up in the CC&Rs to be passed through to the owner. And so in some cases, it allows the association, if your documents allow this, to lien the property of the owner for this cost. In other circumstances, it just is something that we can get a personal judgment against the owner for this cost. A couple thoughts on this. Sometimes the association, will send in a landscaping crew under the self-help provisions. And the owner's okay with it because they don't want to do the landscaping, and for whatever reason, they're not doing it. And so it kind of turns into this unhealthy situation where the association is going in and cleaning up this owner's property. The owner refuses to pay the money for the cleanup. And at some point, sometimes we see the owner lose the property at a trustee sale, and the association doesn't recover any of the self-help costs that they've incurred. So what I typically will tell clients is if you're thinking about doing the self-help option, recognize a few things. Number one, you may not be able to collect the amounts that are owed, because sometimes we go in and do self-help and clean up a lot when we have an owner that's deceased, or we have an owner that there's going to be a trustee sale in the future, and the property looks horrible and the neighbors are complaining. And so we just want to go in and make it look better, so we stop getting complaints. So self-help is tricky in that manner because we're fronting the costs, and there's a possibility that we may not ever recover those costs. Okay, another thing just kind of important to remember is, having some sort of a policy in place on all of these violations, whether it's a fine policy, an enforcement policy, and then communicating to your members, okay, here are our policies if you violate the documents. So we have the right to fine. We, have the right to do self-help if that's in your documents. At a certain point, we're going to go the legal route, turn this matter over to the attorney, go the legal route and file a lawsuit. Maybe we go to the Arizona Department of Real Estate. So having that policy in place, and it makes your board accountable too, so that you don't let violations just, linger on for months and months and months and years. It kind of sets into place, a procedure for how you're going to handle violations uniformly against all owners. Okay, so let's talk a little bit about when are you going to get the attorney involved to help your association navigate the violation. So by now, you might be down to 5% or maybe 10% of your owners haven't complied based upon all the different things that we've done. So we may have done the courtesy reminder notice, then we did the formal violation notice. Maybe we threatened and levied fines. Maybe we threatened self-help, or maybe we actually went in and did self-help, and now there's some charges with that. So typically the attorney gets involved at the point where the management company or the board is unable to resolve an issue with an owner. And, there's a couple things that we do. I mean, it just depends. Every case is different. And so when a file is turned over to our office to handle a violation, we typically ask for photographs and we ask for the history as to what's happened on this file. Are there any special considerations for the owner? Do we know anything about the owner? Are they offsite? Are they an owner or landlord? Is there a tenant in the property? Do they live out of state? Do they only live here part-time? A lot of good information is helpful to me so that I can make a good choice about how we want to proceed. But when the matter is turned over to our firm, we typically will send a first violation letter right away. And in that letter, we're going to continue to threaten fines. We're going to threaten a lawsuit against the owner and let them know how much a lawsuit is going to cost in terms of attorney's fees and costs, because that may be something that will be a motivator for them to do whatever they're supposed to do under the documents. Litigation is a last resort from my perspective. Typically what we'll do is we'll send the first violation letter from our firm. And in addition to that, I always pick up the phone and we'll contact the owner directly and try to get some FaceTime with them, ear time, whatever, and talk about the violation and find out where they're coming from and see if we can come to some common ground. I would say probably 8 out of 10 times that works and we get the owner to comply, especially after we explain to them how much it's going to cost in legal fees, in addition to the fines and maybe any self-help charges that the association may be charging. I think most owners recognize we don't want to, pay the attorney. We just want to fix, the problem. But in some cases, we're forced to file a lawsuit against the owner. And here's just kind of the process that we follow when have a violation and we are, pursuing the owner through litigation. So basically, like I said before, litigation is going to be a last resort. It's not something that we just pull the trigger and do, right away. This is something that is set up really well with documentation of letters, trying to reach the person by phone. And this is our last resort. So basically what we do is we file a lawsuit in Superior Court. We ask the judge for a mandatory permanent injunction compelling the owner to do or not do something. In most cases, the judge is going to rule on this by a default hearing, and we will be entitled to our reasonable attorney's fees and costs incurred. In some cases, right after the lawsuit's filed, the owner will contact us, or maybe the owner hires an attorney, the attorney contacts us, and we're able to resolve the issue. In some, very limited cases, like maybe 1% of the time, the owner, doesn't do anything. Or maybe we have to, go the phase where they have an attorney and they file an answer and, they claim that they don't have to do this, or they have some sort of defense as to why they're not doing it, and then we have to litigate the matter. In terms of timeline and costs for, lawsuits like this, if it's the type of lawsuit where it's just going to be a default judgment, meaning that the owner never responds, we're probably looking at about $3,000 to $4,000 in attorney's fees and costs. If this is something that we have to go to a motion for summary judgment and have the court decide as a matter of law who's the winner in the case, it could be as high as $10,000 or $15,000 in legal fees. So lawsuits are expensive. It's something that we want to take care and consideration before we file the lawsuit. Typically, I'll ask to meet with the board and talk about the costs and the risks of litigation and how long it's going to take, so that the board goes into the lawsuit understanding, what the procedures are and how much it's going to cost. Again, the reasonable attorney's fees are regularly awarded in these type of cases. These are not difficult cases. This is a simple breach of contract case. And we just bring the evidence to the judge and show them the contract, which is the CC&Rs. And, it's a pretty easy case for the court to rule in the association's favor. In some cases, we have owners that we file a lawsuit against them. They never respond. They don't clean up their lot. And then we get to the stage where, okay, now we have a court order telling the owner to do something, and the owner still won't do it. In those cases, the remedy that we have is we go back to the court and we ask for the court to have an order to show cause hearing, whereby the court demands that the owner comes to court and basically tells the owner, if you don't do what you're supposed to do, you'll be held in contempt of court and you could potentially go to jail. And I have unfortunately seen that happen a few times in cases over the past 25 years. It's not that often, but so there is a lot of, enforcement teeth. If we file a lawsuit and get a judgment against the owner, they will have to comply. There's no way around it, basically. And so, that's basically just the overview of the most serious remedy, which would be, going to Superior Court and getting an injunction against the owner, compelling them to do something. There's also another remedy that I want to mention, and that is going to the Arizona Department of Real Estate. We're going to be sharing with you the Homeowners Association dispute process with the Arizona Department of Real Estate. Several years ago, probably now maybe 5 or 6 years ago, the Arizona legislature passed a law, and this law allows owners or associations to have their disputes regarding their association heard by the Arizona Department of Real Estate's administrative law arm. And so some associations and mostly owners use this department to have complaints heard. The reason why, associations don't typically go to the ADRE, the Arizona Department of Real Estate, and file complaints or petitions against their residents is because the ADRE does not authorize or award attorney's fees. And so basically it doesn't make sense, for the board to go to the ADRE because they have to have an attorney representing them. By law, all nonprofit corporations do have to have an attorney in any court proceedings. And so it wouldn't make sense because the association would have to hire the attorney and then just pay out of pocket and not have any reimbursement from the owner for going to an administrative law hearing on, a dispute between an owner and the association. Now, owners love this section of the Department of Real Estate because that works in their favor. So for a small filing fee of $500 per claim, owners can go to the Arizona Department of Real Estate and file a petition against an association for one issue. It's $500 per issue. So if they want to have 3, then it's going to be $1,500. And basically what happens is the Arizona Department of Real Estate refers the matter to the Arizona Office of Administrative Hearing. And there's a hearing on the petition, usually within 3 or 4 months of the petition being filed, and the administrative law judge, will make a ruling after the hearing. So there are some benefits of, going to the ADRE, and that would be that it's relatively fast. You usually can have an administrative law judge make a ruling on this within 4 or 5 months. And it's relatively inexpensive for owners at $500 per issue heard. And so there are some benefits to that. I mean, I can think of, maybe 1 or 2 times that the association has used the ADRE to hear complaints. Most of the time, 99.99999% of the time, this is an avenue for homeowners to use if they're upset with their association. The risk is that they have to pay the $500 filing fee. If they win, the other side has to pay that fee. If they lose, they obviously will just eat that cost. If you want more information on this process, you can go to the website that our office is going to be sharing with you on Zoom and also on Facebook Live. And they'll give you some more information on how to submit a petition, the forms that you use. And I think you can actually submit the petition online now too and pay the fee online. Okay, so basically, I think we covered everything in terms of our, different enforcement things, just as a quick, summary of everything. When you have a violation, it's really important that you document all of the evidence. So take photographs, have a log as to who's complaining about the violation, what exactly the violation is, who went out to observe the violation, or maybe if it's a homeowner complaining about it, when they observed it, because we need all that important information as we progress through the different steps. And the different steps, like I said, are going to be a courtesy violation letter, a more formal violation letter, fines, self-help, escalating the matter to the attorney for the association, having the attorney send a letter, a lawsuit, potentially an injunction issued against the owner, compelling them to do something or not to do something. And then, of course, having the Arizona Department of Real Estate as a potential venue to hear disputes between the owners and associations as something just separate that's out there that you need to be aware of. A couple things in closing on enforcement actions. Our firm is offering right now, if you have a pickle enforcement, so one that's really difficult for you that you haven't been able to figure out for your association, we're happy to do a free 10-minute consultation on that particular issue and give you our best advice on how to handle it. So if anybody is in that situation that's listening in today, and gosh, we have a lot of people listening in today. We have 91 people here on Zoom and many more on Facebook. So, that's great. Okay, we just launched a new poll. So I want to make sure as we kind of transition over to our most common violation issues that I'm asking that you kind of help me with this answer. So I get feedback from you. What enforcement issue does your association struggle with the most? So we kind of put the most common ones up there. And I can see that the results are coming in. And I also don't want you to forget that. Don't forget to ask questions. You can do that through the comment section on Facebook Live or through the chat box on Zoom. One of the first things that we're going to talk about here in a second, I'm just kind of waiting for the poll results to come in, is what are the most common, violations that we see. So number one, I think, is right now is short-term rental issues. Parking problems is another really common one. Not submitting architectural applications, not maintaining property, and then collection of delinquent assessments seem to be the ones right now that are kind of the most common ones. Okay, so let's go look at our poll here. What enforcement issues does your association struggle with the most? So we have 12% of you are having trouble with short-term rentals. 26% of you are having trouble with parking. 37% are on maintenance of property. And then 25% are on making changes to property without getting architectural approval. So what I'm going to try to do is spend a little bit of time on the ones that you have, it seems that the group has the most serious issues with. Let's start out with rental properties. And I'm kind of surprised that only 12% of you have issues with that. But we have a great cheat sheet that we're going to be sharing with you called How to Effectively Work with Rental Properties. And that contains some great nuggets of advice to help you as you navigate working with rental properties. A couple quick pointers on rental properties. Remember that the owner is responsible for the behavior of the tenant. So as you're working with a rental property, if you have a bad tenant, the best way to get compliance is to contact the owner and make it hurt in the owner's pocket. So we've been really effective in getting landlord owners to either evict tenants or get the tenants to comply with the documents by, once the file is turned over to our firm, I contact the landlord owner by phone or by email and ask for a phone call with them. And I just explained to them, listen, you're responsible for the behavior of your tenant, and this is what your tenant is doing. And ultimately, this is going to cost you a fortune because we're going to pursue this in a court of law and we're going to fine you. And it would be much smarter for you just to comply because this tenant is going to end up costing you way more money than you're getting in rental income. And, if you set up that call right, I basically have like 100% success rate on that because I just lay it out for the landlord and you have to think like a landlord. They're operating this property to make money. And once that, it's a business for them, basically. And once the business starts losing money, they've got to pivot and change course. And that pivot is to get rid of the tenant or to get the tenant to comply. And that is a very effective way to get the landlord owner to comply. A couple quick reminders. Associations can only ask for certain information from landlords regarding their tenants or their leases. And so basically this is all set up under the law. So we can only ask for the name and contact information for adults who are occupying the unit, the time period of the lease, including the beginning and ending dates of the tenancy, and then a description and license plate number of the tenant's vehicles. There's a fourth category. If you're a 55 and over community or an age-restricted community, the owner's agent or the tenant must provide the association or a manager of the association with a government-issued identification with a photograph, and to show that that tenant meets the minimum age restriction. Might be like 55 and over for the community. At least one occupant would have to be 55 or over. The association can charge a fee of no more than $25 to provide this information to set up the new tenancy in the association's books. That fee can be charged for any new tenant, including any new short-term tenant that might be renting for a short-term period. But it cannot be charged if the same tenant renews an existing lease. We have a great blog that I'm going to share with you on vacation rentals and short-term rentals. And I think it will be really helpful if you're having any problems with short-term rentals right now in your community. Remember, it's kind of the same game plan on short-term rentals, or even really if you have a long-term rental in your own association that's a bad rental. Basically, you want to look to the new legislation that was signed into law in July and what became the law effectively on September 24th. And basically, you want to check in with your city to see if they have any special requirements for short-term rentals. They may have ordinances in place where if you complain about a short-term rental, that they will investigate it. They may have set up a whole procedure for permitting of the short-term rental, and any complaints regarding that permitted short-term rental will go in that owner's file, and it's possible that the permit will not be renewed in the future. And so you definitely want to check in with your city, town, or municipality to see if they have implemented any new special short-term rental restrictions. But again, on short-term rentals, basically the same thing. We contact the owner, we explain to the owner how much this is going to cost in terms of legal fees and fines. And we have good documented evidence to show the landlord owner about all the violations. And, we try to get the owner to understand that, hey, this tenant is costing you more money than you're making. And that will hopefully either get the landlord to evict the short-term tenant or not rent to them in the future, or try to find better short-term tenants, maybe not transient tenants, and maybe go with a longer-term rental in your community. Okay, so I do want to encourage you, just kind of as a closing remark on this, make sure you're checking out the new legislation that was just signed into law. We shared our cheat sheet with you on this about short-term rentals. I think that contains some really great information for you about the new legislation and how you might be able to work and partner with your city, town, and municipality to best manage bad short-term rentals. Okay, another problem which we saw, 26% of you here on this call today said that, hey, we have parking problems in our community. So when I'm looking at a parking issue for a community, what are some things that I look at? Number one, I check the documents for the association. What do they say about parking? We have to look at the exact language of the documents and look to see if what the owner is doing or the tenant is doing is violating the exact language. Most common parking issues we see are overnight on-street parking, bringing in RVs, campers, boats, trailers, commercial vehicles. These are all very common violations. We have to determine who's going to enforce this and who's going to give us the evidence that they're violating it. Is it going to be neighbors reporting it? Is it going to be a security patrol? Is it going to be the manager? And then how are we going to enforce it? Are we going to send letters? Are we going to fine the owner? can we tow? So towing is kind of a controversial remedy. It needs to be in the CC&Rs. Same thing with booting a vehicle that's parked in violation of your documents. The right to do that needs to be in your CC&Rs. So make sure that if you're engaging in towing or booting of vehicles, that you have the right to do that listed in your CC&Rs. Some other things that we do are sticky stickers on a driver's window. Lawsuits are another thing if we've got a habitual offender. Parking problems are messy. It's difficult to prove whose vehicle it is, and if that ever happens to you. We have our process server can look up license plate numbers, so we can determine who owns the vehicle and then try to trace it to where are they going in your community. But oftentimes the neighbors, see the person park the car and then see the person walk into the lot. So we already know which owner is responsible for the person that's parking in violation of the documents. But again, same analysis on parking problems. We go through the process of violation letters, escalate it to the attorney, and then kind of last resort would be to go to Superior Court and file a lawsuit against the owner for the tenant's behavior or the owner's behavior in parking in violation of your association's documents. Another very common violation is going to be not maintaining property or also failing to submit architectural applications. It looks like we had, 25% of you say that that's a big problem in your community. We have a lot of cases right now where owners make a change to their property without getting approval. And so failing to obtain architectural approval, the most common things we see are maybe they repaint their house, they put up a new garage door, they change out their windows, they add a bonus room, they change their landscaping, they put in an RV gate or a golf cart concrete pad, they add a shed to their property. I mean, there's all kinds of things that people do without getting approval. So first thing I would say would be check your documents to make sure that what the owner changed does in fact require architectural approval. The best way to handle is to contact the owner and ask the owner to submit the architectural application after the fact. And then, the board needs to review the application once they submit it. Maybe it's something that the board will approve, maybe it's not. If they don't approve it, the board may have to require the owner to return their property to its original condition. And a common question I get is, okay, if the owner already, added a concrete pad for golf cart parking, and we would not have allowed that if they had asked for permission before they did it, does that mean we have to allow it after the fact because they spent the money and, they put it in and, do we have to allow it because of that? And no, not necessarily. When you get into one of these sticky situations, it's really a good idea for you to talk to your legal counsel and talk it through with them in terms of, what is the violation? Did they submit an architectural application? Did we give it a fair review? And if it's a violation and you're not going to allow it, then maybe you need to get the attorney involved to send a violation letter on it. Again, same legal remedies that we would have for the other violations, sending letters, fining, possibly self-help, and injunctive relief lawsuit. Okay, failing to maintain property, this is a big one. As you know, we had 37% of you who are on this Zoom and Facebook Live today with us have told us that this is, a big issue for your community. So how do we handle failing to maintain the property? Make sure that you're doing regular inspections because, you won't let properties fall into disrepair if you're doing a regular inspection every month at your community. Sending out the letters when you see properties that are not in good condition. Using the self-help option that we talked about, giving notice and then going in and cleaning up the property or even threatening to do that is a good way to get people to comply. Fining the owner, considering a lawsuit, having really good documentation regarding the condition of the property with pictures, for every violation visit that you have, when you're going out there to do an inspection, taking pictures so we can see what has been corrected or has not been corrected. If you find out that this is a difficult situation with an owner, like maybe they have a health issue, or maybe there's been a recent death in the family, being creative in finding ways to help is a really great solution too. So there are organizations throughout the valley that will send in a crew to clean things up. Maybe the neighbors can volunteer to help this owner during this difficult time. So it's really important to have good communication with the owner to find out what's going on. Okay, our last topic that we're going to talk about is kind of another very large enforcement issue, and that is collection of delinquent assessments. And we're going to be doing a quick poll here, and we'll be sharing that with you on your screen here in a minute. But the poll is, has your association noticed an increase in the past 6 months of delinquent owners? So, have you seen, has there been an uptick in the number of owners who aren't paying their assessments? Okay, we're going to be talking about this topic pretty quickly, but we have a deep dive handout for you, a cheat sheet, and it's called Our Firm's Secrets to Effective Collection of Delinquent Assessments. And then what are the legal remedies that you have if you're trying to collect information, or you're trying to collect unpaid assessments from an owner. Okay, so we're getting our poll results back, and we're seeing that 29% of you who are on the call here today are starting to see an increase in the number of delinquent owners in your community. And I think our firm is also seeing an uptick in the number of delinquent owners. We've kind of been scratching our head wondering, since 2020, when the pandemic initially started, there was so much money being pumped into our economy from the government. We actually saw more owners paying their past due assessments to the association. But most recently, with the inflation rate increasing and the government not really pumping any more good money into the economy, we're starting to see things go back to pre-pandemic delinquency levels. And so it's important for associations just to keep an eye on your delinquency list in your community. So every month at your board meeting, your board should be looking at the delinquency list and, having a policy in terms of, okay, if an owner is 60 or 90 days past due on a payment of assessments to the association, your association should be liening the property. Maybe when it's 30 days past due, we send a letter. When it's 60 to 90 days past due, they're liening the property. And then maybe at 120 days, it's sent to the attorney to take legal action. So when a file is turned over to our firm to collect money against an owner, basically what we do is we do a full 360 credit review of that owner. And we determine whether they're collectible. We determine, are they employed? Are they underwater on the property? Do they owe more on the mortgage or deed of trust than the property's worth? What does their credit card debt look like? Is the bank that they have the loan with, are they foreclosing on them too? Are they in bankruptcy? I think I may have already said this, but do they have a job? Is the job information current? Are they driving fancy cars? Are they taking vacations? Are they documenting all this on social media? These are all important factors to take into consideration in terms of how we're going to collect the debt. And basically, we have a couple different remedies. We typically will start out by sending a demand letter, which outlines the fact that we have the right to foreclose on the assessment lien if they don't pay their assessments. There are some restrictions under state law. We can only foreclose against an owner once the assessment is 1 year delinquent, where they owe $1,200 in assessments only. So that's kind of like the benchmark. We can't foreclose until it gets to that amount. But foreclosure is a great remedy because right now, most properties in Arizona are there is equity in the properties. And if we threaten to foreclose, people are going to realize, hey, I maybe owe $200,000 on my property and the property's worth $500,000. That means there's, a lot of equity, $300,000 of equity in the property, and they're not going to walk away from that. So if we threaten foreclosure, we actually foreclose. In those situations, we're guaranteed to get the money back because either the owner is going to wake up and pay, or we're going to have a sheriff's sale and a third-party investor is going to come in and see what a great deal this is and how much equity there is and pay the association in full and buy the property at a sheriff's sale. So foreclosure is a good option right now with our economy being in the state it is. There's also a second remedy that we can go and get a personal judgment against the owner in justice court. And with that judgment, we can garnish their bank account, their wages, or if they're a landlord, we can garnish their rents. It's interesting. Over the past 25 years, I've seen different cycles where, especially based upon how the economy is doing. So when the economy is not doing well, getting a personal judgment is usually the better option because the owners don't have as much equity in the property. And, oftentimes we will just get the justice court judgment and then garnish their wages if they're working. But the past 4 or 5 years, there has been so much equity by these owners in their property that it's kind of a no-brainer to us that we should just foreclose, threaten foreclosure or foreclose, because we're going to get paid. And it's a little bit easier than going the justice court route where we actually have to get the judgment and then go after them and garnish 25% of every paycheck that they make. And so there are legal remedies. If you have owners that aren't paying, it's really important that you get on top of that debt early. Do not wait for that debt to be a year behind to turn it over to the attorney. You want to get that to the attorney, once the debt is somewhere between 4 and 6 months behind. And keep an eye on that. Every month you should be looking as a board member at the delinquency list, at the violations list for your community, and determining, okay, what's the next step here, for us to get compliance, either for the owner to pay or for the owner to bring their lot into compliance. Okay. We have one last poll question before we go into the questions that we have today. We have 18 questions right now, and it looks like more are rolling in as we're just rounding out our hour of the presentation. Our last poll question for today is regarding virtual learning, and we're starting to plan our classes for 2023. And, since the pandemic started in March or April of 2020, we have taught many classes. I'm guessing probably at least 60 classes virtually, and we've had a significantly larger turnout of attendees when we teach the classes virtually. But there are some people that are still itching to meet in person. And so we think it's important that we, ask this question. As we start to plan our 2023 classes, do you prefer having, more virtual, or would you prefer to have in person? So that was our poll question number 5. And so the question is, do you like the flexibility of virtual classes, or would you prefer to meet in person? Okay, so you've spoken. The results are back. 90% of you prefer having virtual classes. 8% prefer to do in-person classes, and 2% are unsure. So that's great feedback for us as we continue to plan our curriculums for our neighborhood services virtual HOA Academy in 2023. I know that it's hard not seeing you in person. I miss not having that personal in-person contact, but I do feel like I'm able to answer more questions and to get through the materials. And to provide, written things to you in such an easier format when we do teach it virtually. So I have to admit that I also do prefer doing virtually because I think I reach more people and I'm helping more people and getting more information out there. So thanks everybody for participating. Make sure that you're checking out our Facebook page for Mulcahy Law Firm and liking it, and subscribing to our YouTube channel because we're putting all kinds of great content and free information on there for board members, managers, and homeowners. We've reached a total combined views on our YouTube channel of over 63,000 views since April of 2020. That is beyond my wildest dreams in terms of the popularity of these classes and of the videos that people are watching after the classes. So thank you so much for supporting our firm and supporting the different neighborhood services departments for all of these different cities, towns, and municipalities that we're working with to provide this free education to you. We also have some great free resources for board members. We've shown you a couple of cheat sheets today during this presentation. Our website at mulcahylawfirm.com has all of our cheat sheets, all 60 of them, all of our past videos that we've taught over the past 2 years as well. So I really encourage you, if you're looking for information or looking for answers to questions about how to run your association, is my board doing things correctly, go to our webpage at mulcahylawfirm.com and look at all of our free resources on there for you. We get a lot of positive feedback from owners and board members and managers about how easy the website is to navigate and how thankful they are to have a resource to answer questions. So we encourage you to take a look at our website. We also started a podcast, and you can find information on that on our website as well, or contact our firm. Also, don't forget, we have our virtual First Friday free call-in on Friday, November 4th at 9 a.m. We always have a great turnout of people asking questions, and we usually get through 50 or 60 questions each First Friday. So hope if you have any additional questions each month, make sure you're tuning in for that on Zoom and Facebook Live. Additional details can be found on that on our website, and you can continue to submit questions right up until the morning of November 4th. Thanks again for being here today. It's our pleasure to partner with the neighborhood services departments from many different cities around the valley to create this free education for board members, homeowners, and managers. I'd like to give a special shout out and thank you to the cities of Avondale, Chandler, Glendale, Goodyear, Mesa, Peoria, Phoenix, Scottsdale, Surprise, and Tempe for being our partners in this virtual HOA Condo Academy. We hope to continue to do programming for you for the rest of 2022, of course, and also all through 2023, so that we can continue to provide you with the resources that you need to make your communities better. So thanks everybody for being with us here today. Take care, everybody. Have a happy Halloween, and I look forward to seeing you in November.